interim prayer will be considered.
Yes.
Okay.
And next one I is there. Another I.
So this is in main.
Yes.
This is in main.
Main, correct.
So in IA also you want
That another I is there for exemption. That
Okay.
day your lordship will, that also I will be heard on that date.
that will be listed also.
Yes, yes.
When it is listed, we'll have hearing
Yes.
on that also.
Right. Only one liberty with your lordship's permission. One liberty also should be given in the main case. Main case, yes, for additional affidavit.
Then we're not allowed. The petitioner is at liberty to file additional affidavit.
In the main case also. In the main case.
Okay, in the IA as well as in the main case.
Yes, sir.
Okay.
And weekly always, sir.
For orders, item number 17.
Well, I hope the respondent appeared here earlier.
Yes, earlier I think that's why I came back.
Yes.
Because your lordship.
They appeared or not?
So I think they appeared.
Steps taken.
Yes.
Just a minute.
That's why I came back. I
Yes,
thought
yes.
that I should inform.
Because the name is not there.
Yes.
Now I could see that there no name reflected on behalf of the respondent.
Earlier orders, your lordship will kindly look into it. First order, if your lordship kindly see.
PP appeared, but just a minute. Public prosecutor ED appeared.
Yeah, ED appeared, that's why.
His
ED is
name
the
is
only
not,
party.
his name has not been reflected.
But anyhow, your lordship can say an exact name can be reflected. Because they will not be prejudiced by because they are not passing
Yes,
any
yes.
interim order.
Okay, then in the last. No? Okay. Earlier, Mr. Y. P. Gupta, Learned Special Public Prosecutor, appear on behalf of the ED. His name may be reflected in the cause list. Okay. As the counsel for the ED. Okay.
Yes, that's better. That's why I thought for a
Right,
moment
right.
that other side is not there.
Yes, because suddenly I
I
saw
remember,
that.
my lord, in this case, when I appeared first,
Hmm,
I told the court also, please do not take up the matter because these are very sensitive matter.
right.
Your lordship should hear the other side.
Yes.
In this case also, I moved some matters. Your lordship was not holding that bench. The honorable other judges were there. So I didn't move. Once I think we moved before your lordship also. Your lordship will not recollect. I told them, please do not pass any order without hearing the
Yes,
other
yes.
side. Because they will again go to the higher court
Right,
and they will
right,
say
right.
that it is not.
That is true. That is true.
I am deeply
Okay.
For orders, item number 17.
May I please, your lordship?
Yes.
Service return upon respondent number 2 is still awaited. So if your lordship may kindly list the matter after 3 weeks.
You are for the petitioner,
Yes, your lordship.
Miss.
Vekrikole. Vekrikole. VE.
Your name is there in the cause list.
No, your lordship.
Okay, give names. Learned counsel for the petitioner is present. The of Miss Mary, you are appearing?
Lordship, on behalf of respondent number 1.
Okay, Miss Mary. Learned counsel for the respondent number. Are you filing affidavit? or
Your
have you
lordship,
filed?
actually, we are not filing, your lordship.
Not filing.
Lordship. Lordship here, N. Angami is appearing, but today he is engaged in court number 1.
Okay,
So, your
so
lordship,
you are appearing on behalf of.
on behalf,
Okay, Miss.
for respondent number 1.
Appear on behalf of Mr. Angami, Learned counsel for the respondent number 1. And some is, you are not filing.
Lordship,
record?
that I'm not, I have
Not
no
here.
instruction. I have no
Okay.
instruction.
Stop, huh? The office note dated 22/2025 reflect that the notice upon the respondent number 2 is still awaited. In view of the above, list is matter after
3 weeks.
3 weeks. Okay. In view of the above, and as prayed for by the Land Council for the petitioner, list is matter after 3 weeks. Okay. Yes.
For orders, item number 18.
No one appear on behalf of the applicant on call. Start. In absence of any representation from the applicant, the matter stand adjourned. List is matter after 2 weeks. Okay. On the date to be fixed by the registry. Huh?
For hearing, item number 19 to 22.
Yes, Mr. Pong.
Yes, your lordship.
So, are they appearing?
Lordship, my senior, he's in court 1. I think even the government advocate, he's also in court 1.
Okay. Now, in that case, so otherwise all of them are present in the.
Yes.
Lordship, yes.
Okay. But in any case, yes, it can be hard, but then CAB, it will be difficult to carry.
Your lordship, my only, I will just submit in a nutshell my case, because that is the crux of the case. The first order whereby my father was granted the land by the,
Have you
Yes,
submitted
yes,
the written,
yes, I have submitted the written
okay, submission?
submission, yes. And then,
Where will we find? Just
yes,
review the.
yes.
May I please, my lord?
Yes.
Your lordship, I have one admission hearing, item number 3, court number 1. So if my concluding submission can be recorded
Okay. Afterwards.
afterwards, your lordship.
Okay, we'll fix this and we'll have hearing from the petitioner side.
Yes.
Okay, and your side will have, because in any case, what this morning, when I was looking at, it is bulky. And since
Yes.
I'm leaving tomorrow morning,
Yes, my lord.
it will not be possible for me to carry all this.
Correct.
So that is why, otherwise, after next week, next to next week, I am coming. So what we can do is I'll have hearing from the petitioner side, and your side, I'll have hearing on the next date.
Lordship.
On next date, we'll pass order.
Lordship,
Okay, so,
lordship.
but then from his side,
Yes.
if it is possible, then we'll let him conclude from his side.
Lordship,
Do you have any objection?
in fact, your lordship, the petitioners and the state respondents, we have already submitted our
Submitted.
part. Yes, just the concluding submission was
Okay,
there, but then
okay.
the private respondent actually
Oh.
they are supposed to.
We have
Okay.
already filed.
And then Mr. Santiago also, was.
So, Lordship, I'm appearing now, Lordship, yes,
On behalf of the newly implemented respondent?
Yes.
Okay,
I've already filed my affidavit, Lordship.
you have filed affidavit. Have you
Yes.
served a copy of the affidavit to the Learned Counsel for the petitioner?
We have already served.
Yes, we have received it, yes.
Okay, you have received.
Yes, Lordship.
Okay,
Now, Lordship, my objection is with regard to the maintainability of the writ petition, Lordship.
okay.
Now, this is purely a disputed question of facts. Whether this writ court can interfere, Lordship. Where now the claim of the petition is that the property is in my possession. I am the village who has donated the land to the government.
Now the property is under whose possession, you said?
It's with the government. But the petitioner is claiming that this is my property.
Hmm.
Because the petitioner, late father, got the permit to utilize the land for cultivation. Whether the permit can be transferred to the petitioner in lieu of the permit that was given to the father. It's not a pata. It's a permit to cultivate over the land. Because I'm the concerned village who has donated the majority of the land for setting up the Tizit town. So, Lordship, on that aspect of the matter,
Hmm.
first thing, whether the petitioner by
Now, Mr. Powner, he's raising some new questions.
yes,
So,
Lordship.
your lordship, the fact is this,
Hmm.
the chief secretary has directed.
Is it allotment or is it patta?
It was in the 1960s.
Yours.
In
Special
1960s,
permit,
special
special
permit was given to my father for his services to the state by the administration. Now, in 2006, the then chief secretary directed the deputy commissioner that this is an allotment which was specially granted to the petitioner's father.
Okay, so it
State
was
government cannot.
converted into allotment.
That was, no, it was not converted to allotment, but the chief secretary clearly wrote to the deputy commissioner,
Hmm.
the administration must honor whatever earlier administration has taken. And it was a special permit given to the petitioner's father, it should be protected. So as the state government cannot do anything what it wants. So a special inquiry report be submitted before me. That was the commission chief secretary's direction. Since no action was taken, the petitioner approached this honorable court. This honorable court, by the judgment, by order, also held that yes, the petitioner's right ought to be protected. So, in accordance with the chief secretary's direction,
This court,
yes,
have you annexed that order?
yes, very much, Your Lordship. Page 50, Your Lordship. Annexure J.
Just a minute. Page 50 of your petition.
Yes. It's a very short order, Your Lordship. The,
Just a minute.
yes.
No.
No. The last, read petition 88, Your Lordship.
Which petition?
Because, yes, it covers the entire three read petitions. All the facts in the three read petitions are also here. So I'll take Your Lordship to the read petition number 88. of
Read petition number?
2022. 88
88, okay.
of 2022. In all the read petitions, it is annexed, Your Lordship.
Okay,
But I'll confine to the WPC 88.
Okay, 88 page.
Page 50, Your Lordship, annexure J.
Five zero.
Yes, 50. Annexure J it will be, Your Lordship.
Yes.
Annexure J.
Hmm.
It is
Yes.
order judgment and order dated 5/8/2014.
Yes. Hmm.
So all subsequent actions of the state government must be judged on the basis of this direction, Your Lordship. That is my case.
Just a minute. Huh?
Yes.
Where is the operative portion?
So operative portion is paragraph 5.
Mhm.
Paragraph 5, 6, and 7, Your Lordship. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum dated on 11/4/1975, recognizing the same. If there is any encroachment, definitely this is prejudicial to his legal and constitutional right. The Chief Secretary of the State, being aware of the situation, issued direction to the Jurisdictional Deputy Commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold a special inquiry as directed by the Chief Secretary, although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible. But the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the chief administrator of the state has been stopped. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic setup of governance. 6. Although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed. The fact as to issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold special inquiry as was directed by the Chief Secretary by order dated 18/7/1996, Annexure A, within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. The petitioner shall forthwith furnish a copy of this order to the Deputy Commissioner Mon and shall get necessary acknowledgement on the body of the forwarding letter. So,
It was inquired into.
yes, now the court clearly upholds the Chief Secretary's letter and the earlier administration letter that it was validly allowed to the petitioner, his right ought to be protected. And since the Chief Secretary has written to the Deputy Commissioner to conduct an inquiry, it should be conducted and submitted before the Chief Secretary for ordered.
Inquiry is conducted
Direction.
accordingly.
Accordingly to issue pass appropriate order. Now, the Chief Secretary's letter direction to the administration, only these 2 records are the most pertinent ones in my case, Your Lordship. I'll take Your Lordship to the,
Just a minute, I have also noted down something. Let's see that.
Chief Secretary's letter dated 1996. Oh, yes,
Just a minute,
Your Lordship, page 40,
just a minute.
yes.
Yes, already gone. No problem. Lordship, that is a contention of the writ petitioner.
Hmm.
Now, Lordship, the fact remains. Lordship, may kindly appreciate my affidavit, annexure 1.
Now, whether the, just one question before your submission,
Lordship.
just short. Whether, have you challenged the direction issued by the chief secretary?
No, Lordship, I am the respondent here. I cannot challenge. Now, this writ petition, the earlier writ petition,
Hmm.
has been filed. I'm not a party in the case.
Okay.
I was never a party. I was never made.
Earlier petition also you have not.
Yes. But
appealed.
now, here,
Hmm.
we came to know about the claim of the petitioner. So, Lordship, we have filed an intervention application. We have implemented ourselves as respondent number 6.
Hmm.
Now, we want to bring straight on record how this TISIT circle was established. Lordship, may kindly see annexure 1 of my affidavit. That will show some clarity of my affidavit, Lordship, please. If my Lordship may kindly allow me.
So
In the WPC number 88,
88.
yes, my affidavit in opposition. Because there's been a wrong interpretation of the special permit by the government also. I just want to clarify on that line, Your Lordship.
This affidavit in opposition by respondent number 6.
Yes, Lordship.
So where is the affidavit by respondent number 6 in 88? What could you find? Hmm? Is it available there?
WPC 88.
Yes, it's in 88.
Yes, in 88.
Just a minute, and this is affidavit was 6 in 88. No, this is in 207.
Lordship, if I may be allowed to, in
Affidavit.
88.
88. Give it.
No, this is 88. Because I did it myself. You're 6. You're 5 kilos. Yes.
6, no? Yes.
Lordship. I think the copy is okay. Should be 6. Lordship, may kindly come to my affidavit.
This is respondent number 5.
Yes, Lordship. There's some typographical error. It's actually
Okay,
should be
that's
6.
right. Hmm.
6.
Okay.
So annexure 1, Lordship. If I may be allowed to correct that affidavit later, Lordship.
Okay.
6. Annexure 1, page 7, Lordship, of my affidavit. The type copy is page number 8.
Yes.
Copy of the first agreement in connection with boundary of administrative headquarters. It should be 5. Actually, it's 5. Yes. Actually, it's 5. In my copy, I've made it 6.
Okay.
We'll correct it, Lordship, on copy. Now, Lordship, I'm allowed to read the content. This is dated 13 June 1978.
Hmm.
Permit was granted to the petitioner in 1971.
Hmm.
Petitioner's father was granted the permit way back in 1971. Now, this is 1978, Lordship. As agreed earlier, we, the Ang and GBs of Jaboka village, this is the respondent number 5, do hereby donate a plot of land measuring 1,200 acres. That is approximately 2 square miles, free of cost for establishment of TISIT Circle headquarters. The boundaries, Lordship, as shown. This is very much within the land we donated. And this has been duly signed in presence of the circle officer. This is it. Next page, Lordship, page 9. Lordship, may kindly see page 9. On the left-hand side, bottom, Lordship. This circle, LTWTO, circle officer. Earlier, they were EAC, now they are EAC, but they were earlier not called as circle officers. So this is purely a donated land of the respondent number 5.
This was in the year
1978.
1978.
Yes.
So the petitioner was
Father was allotted way back in 1971.
71.
Yes.
So this is only after.
Yes. Now,
You-
Lordship, may kindly read the content of the special permit.
Special permit to.
Yes.
Petitioner.
This is not a pata. Lordship, had it been a pata, I will totally agree to the petitioner claim. See, Lordship, may kindly come to the writ petition, page 32. The WC 88. Same writ petition. 88, yes. In the writ petition, Lordship.
Yes.
Special permit. And this special permit is given not by the chief secretary.
No, page 88.
No, page 32. WPC 88. WPC 88, page 32. Annexure B1, the type copy, Lordship, page 32.
Yes.
Lordship, may kindly see the type copy, page 32.
Yes.
Government of Nagaland, Office of the Additional Deputy Commissioner, Mon Subdivision. Mon.
Yes.
Lordship, may kindly see the head note. Special permit for farmland at Digit. Sri L. Wangsha Konyak, that is the father of the petitioner, Lordship, regional council member, is allowed to continue cultivation. It's not allotment. Lordship, may kindly appreciate this aspect. To cultivate. Lordship, the issue of ownership and possession is there. He is in possession of the land. He is not the owner. Is allowed to continue cultivation of the low-lying area which we had already put under paddy cultivation. It should be paddy, not petty. Paddy cultivation at Digit. The line of demarcation will be as follows. 1. A straight line will be drawn from point to Sonari Mon Road. Lordship, may kindly come to my affidavit, the boundary. South. Lordship, my affidavit, Lordship, page 98.
Yes.
Lordship, may kindly see serial number 4, south, the boundary. South along the Mon Sonari Road. It's touching my land, which I have donated to the government. A straight line will be drawn from a point on Sonari Mon Road. That is my boundary. The land I have donated to the government. In the survey map, till it join another survey mark near the private track as shown in the survey map. From the survey mark point, it will run straight. Lordship, that is the area where he is allowed to cultivate. An allotment order does not read in this manner, Lordship. A clear demarcation was made where he can cultivate. Lordship. Lordship, may kindly appreciate this. Apparently, the Chief Secretary's letter is speaking something different. Lordship, may kindly the Chief Secretary's letter. Page 42, the type copy, Lordship, of the writ petition again. Lordship, may kindly see. Page 42, which my learned friend has read earlier. How it has been wrongly interpreted by the Chief Secretary. A highest ranking officer of the state is wrongly interpreting the special permit issued by the Additional Deputy Commissioner. Lordship, may kindly come to page 42.
Oh, 88.
Yes.
Okay,
Lordship, page 42 is the type copy, Lordship.
yes.
A representation has been submitted to me by L. Nokchang Wangshu, son of late Nokten Wangshu, alleging that illegal encroachment has taken place in the land given to his father. Land given, Lordship. How can the Chief Secretary change the special permit into allotment? Is there any order to this effect? Lordship, the language used. And this situation is going to get worse, Lordship, because we have donated land to the government to develop the digit circle, not to be randomly given to people like this. Inherited, which he has inherited. Can there be an inheritance of a special permit, Lordship? If he so claimed, that's why, Lordship, I'm raising the issue of disputed question of facts. The additional deputy commissioner special permit says something. The chief secretary's letter says that's something different. I am saying this is my land, I have donated. If the government wants to give the land to Mr. A, B, C, whatever, Lordship, I will reclaim my land. I have donated 1,200 acres, Lordship. It's not a small land. We are the main landowners where the digit circle has been created. Lordship, had it been an issue of 1-2 acre, fine. But it's 1,200 acres, Lordship. Chief Secretary says something different. The ADC says something different. But going by the special permit, because this is the point where the petitioner is claiming that my father was given a special permit. If the petitioner claims on the special permit, then it's only allowed to use, not to interpret the Chief Secretary's letter. Not interpreting the Chief Secretary's letter, Lordship. And the earlier order was obtained, concealing all these facts. The petitioner himself knows that I am the original landowner. This was never brought to the notice of the court. My agreement, which I have donated. They have shown, they have projected the case before the courts that this is a government land, and
The land as stated by Chief Secretary was given to the petitioner way back in the year 1971. But
not
it
Chief
is-
Secretary, additional deputy commissioner
Maybe additional deputy by the government.
by the government, yes. Not given,
But you,
not given, Lordship. Lordship may kindly appreciate
to cultivate.
to cultivate, Lordship. To cultivate, given is different.
Mhm. But this, the Chief Secretary
I
interpreted.
may allow one person here to cultivate my
By
land.
this letter, the Chief Secretary has turned it as a given.
Given, yes.
Okay, so
Is it not a question of disputed fact?
now you say that you have donated, but it was in the after 8 years
Yes.
of the land permitted to the petitioner. After 8 years, you says that reiterating the same land,
Yes.
you said that you are donating
Yes.
to the government.
Yes.
When the land was under the possession of the petitioner, now you are saying you have donated to the
Yes.
government.
Lordship may kindly, yes, possession. Ownership, possession are two different issues.
It was under his possession.
Under spot, but the land belongs to me. Formerly, I have donated way back in 1978.
No,
No, Lordship, yes,
No,
I
see,
appreciate,
just a
I
minute,
appreciate Lordship,
because-
yes.
if it was not of the government, if the land was not belong to government, not already donated, then how, on what basis the government has allowed this petitioner to cultivate in the year 1971?
There was no cultivation. As per information, there was no cultivation. The boundary was earmarked by the additional deputy commissioner that he can cultivate, but no cultivation was done.
Maybe, but then in the year 1971, he was permitted to cultivate.
Yes,
That means which later on the chief secretary has termed it as given.
given.
So 91, it is assumed whether cultivation or not. Let
No.
us assume that he was cultivating.
Lordship, may kindly see the
Hmm.
chief secretary's letter.
Hmm.
Land given to his father, which he has inherited.
Inherited by the present petitioner.
Yes.
Hmm.
Is chief secretary interpreting this special permit, Lordship? See the irony, Lordship, of the government?
No, my question.
No, Lordship, I've got a question.
Hmm.
We formally donated the land to the government in 1978.
It was 78 after.
The land was
Hmm.
allowed to be cultivated by the petitioner's late father in 1971.
Yes.
I am not disputing this too.
Uh,
I'm not disputing this too.
Unless it was under the possession of the government.
Government
How the-
government was also only in possession.
Under what authority the government?
That we don't know. But what we know is we donated the land.
No, how the government come into possession unless you donate it, or unless you given it to the government.
1978.
No, 70 later on only.
Yes.
71.
71, we don't know how this has happened. But we know, that's why we are bringing to the notice of the court. We know only in 1978 we have
That is
formally.
only after later on only.
Yes.
70,
We are not,
71 comes.
yes, we were
Prior
not,
to
we
the
were not
78.
aware. We were not aware all this while.
Hmm.
Only when this writ petition was filed, this second round of litigation that is pending before this court.
Now say for example, let us take example. The person is under possession. So, and he has given it to somebody.
Mhm.
Now, can the third person now, after 7-8 years, says that I am giving this land to you, who has already given earlier, some 7-8 years back?
That is the lookout of the government.
No,
That is the
that's
lookout
why
of
I'm
that
saying you
person.
have to prove that on what basis.
Yes.
Why you are saying that you are giving now when
Exactly.
you know that the government has already given it to the petitioner.
Lordship, the fact remains
Hmm.
when it's a traditional land or a village land or a
No,
clan's
that
land.
you have to establish first.
Yes. To establish that, it has to go to the civil court.
No,
Whether this civil court can interpret.
no. So that you have not challenged first. If you challenge the land allotted or permitted to the petitioner, if you're challenging, or if you challenge that, then it will go to civil court. And ultimate land belongs to me. Why? Under what right you have given it to the petitioner?
Now we are before the court, Lordship.
Yes.
Lordship, may kindly appreciate.
Hmm.
Now we are before the court. We are bringing issues,
Hmm.
the actual facts and issues before this court.
No, before
So
that,
when we have come before this court by impleading, they did not implead us as a party. We intervened, Lordship. Lordship,
no, just a minute.
Lordship, may
Mr.
kindly
Moshe,
appreciate,
Mr. Moshe.
things are happening behind our back.
Hmm.
Earlier repetition order also they have
No, Mr. Moshe.
obtained without
Just
us.
1 minute. I'm here to clarify what is.
Yes.
Because the land, government has permitted the
Petitioner's late
disputed
father.
land to the petitioner in the year 1971.
Petitioner's late father.
So
Lordship,
petitioner's
late
late
father,
late
yes.
father. So if you think that this land belongs to you, government doesn't have any right. Was it not duty on your part to challenge the permit given by the government under what right? Because this land belongs to me, under what right you have given this to the petitioner's father?
Lordship, this is an issue.
You have not challenged that.
Yes, this is an issue.
No,
Because
just
we were not aware. We were not aware
No, no,
of
no.
all this. Had I been aware of this aspect of the
you have
matter,
not said that also, I think. Later on also, after date.
Lordship, I cannot alter the facts here,
Hmm.
but I can supplement the facts here as the landowner. I cannot alter the facts. I cannot say, no, this is wrong.
No, that is why.
I cannot
So,
say this is wrong.
If it's true, you cannot alter, but in that is, when you come into when it came into your knowledge that the government has illegally given this land or permitted your land to somebody
Mm.
who is not connected with and without your knowledge and knowledge and information, would have challenged.
Lordship,
Have you challenged?
now the petitioner,
Now also you have not challenged.
we are trying to bring to the notice of the court
Hmm.
by setting straight on record. This is the fact. Now, basing on these facts, whether the court can, in the writ petition 88, quash and set aside the special inquiry report that has already been done.
There have been a lot of subsequent development. In the
Yes,
court,
no, Lordship.
there is a
So
court order
what-
also,
what
high
we-
court order also.
What we are saying before the court now
Mm.
is that these are all disputed question of facts. The writ court cannot decide the title, right, and interest of a land. Writ court has no jurisdiction. The jurisdiction lies with the civil court.
Now,
Can a writ court, in exercise of
No,
power
no.
under Article 26, say that no, this land belongs to so and so?
no, the fact read court cannot. But then, if you are disputing the fact, since the land is under possession of the petitioner now, as of now, is it not you who should file title suit? Disputing if it is a dispute.
Lordship, I've already donated. I have donated.
No, that is why.
I have donated. That means I've relinquished my right. I've donated.
Hmm.
But because of the misuse of my land by the petitioner now, I want to put straight on record. No, Lordship.
Have you written to the government that
No, Lordship.
this particular land was
The
donated for
special
certain,
inquiry was done in our presence also, which we objected.
this land was donated for certain use or for certain purpose, and you are not using these for the purpose for which we have donated, and then so have you asked for or have you written any?
No,
That
Lordship,
is-
very interestingly,
Hmm.
the petitioner is asking for compensation because the administration, they themselves have started allotting pockets of land to the department for setting up of administrative offices.
Now, unless the permit or the age termed by the chief secretary, he was allowed or he was given, unless that is revoked, then he has a right, it appears. Don't you think that
Okay, Lordship. If Lordship is going to raise that issue, then let me come back to the chief secretary's letter, Lordship.
yes.
Is this an order? Is it a direction to the deputy commissioner? Look at the manner the letter was written. It's just like writing a love letter to the person. A representation has been received by me. Is any order passed in this manner? This letter has been purely written to favor the the petitioner. Is this an order, Lordship? I don't think it's an order. He's soliciting the deputy commissioner more to give the land to the petitioner.
Directly to conduct a special inquiry and to submit detailed.
But the language of Lordship, see,
Language you see.
land given to the father
Hmm.
and inherited by the petitioner. How can that be? Lordship, see the manner. Way back in 1996, a 1971 document, Chief Secretary is interpreting in 1996. This is a traditional land of our village, Lordship. The first writ petition order, which my learned friend has relied upon, Lordship, the early writ petition, we were not made a party. This court has been misled. We came to know only this time.
Now, what according to you, the proper remedy you
Lordship,
should have placed?
that's why, Lordship, by humble submission, in my affidavit, I say this is a disputed question of fact. If any parties agree,
Who should be the person who is raising the dispute question or claiming or file? Who should file title suit according to you? Under the circumstances, when the land is under the possession of the petitioner at the moment.
since the petitioner is claiming, let him file.
No, it's under the possession of the petitioner.
No. He's not in possession, that's why he's
Who
he's
is
before
possessing
court.
the land? Who is at the moment possessing the land?
The government.
The government has allotted land. That is how the issue arose on the land. Otherwise, I am in possession of
See,
the land. Is
possession.
Now, if he is agreed,
Lordship,
say for example,
possession.
Yeah.
Lordship may be very careful with the language. He's in possession, not the honor.
Your Lordship,
Admittance.
one thing, I'll just take your Lordship to this. This involves his own father, where the government has directly held that he has no right and he was kicked out. He is missing out this letter. This is 1975. And that donation is a different donation, Your Lordship. This land which was allotted to the petitioner is a different land which was given at the time of setting up the circle. That is it circle establishment. When it was first set up, different villages, they allotted the land. Subsequently, in 1978, they also gave that 1,200. That is a different issue. But here in 1975, the petitioner's father himself tried to encroach on the land held by the petitioner. And what happened? By the memorandum, which is dated 11 April 1975, Your Lordship, Annexure C, page 34.
of,
Page 34. This will clarify the whole thing, Your
of
Lordship.
the 88,
Yes, 88. It's 24, right? Page 34, yes, Your Lordship. 35 is a typed copy. This is passed by the circle officer, then circle officer. If I may read, Your Lordship.
yes, please.
Whereas complaint has been received from GPs and ANGs as well as public of Yongnu village that Sri Nokzam Konyak, Chief Ang of Chapoka village, that is the petitioner, the present respondent's own father, Your Lordship, and Sri Tingpong Konyak, TV, attached to the circle officer's office, Tizit has encroached the land allotted to let Wangshu Konyak, that is the petitioner's father, at Tizit headquarters and now holding by his eldest son, Sri Nokman Konyak, that is the present petitioner. White, the then additional deputy commissioner, Mon special permit memo number so-and-so dated 29 March 1971 under the signature of Sri DCK Lota IAS, the then ATC Mon. I have personally verified the boundaries and shown in the said permit with the help of Sri Pawang Konyak, TB, and Sri Achok Konyak, TB, in presence of the said holder and the GBs and Ang and public of Yana village on 11th April 1975, and found bamboo groves, banana trees, stump of a dead tree, papaya trees, grown prominently in the said boundary. Therefore, I do not find any reason as to how Sri Nokzam Konyak and Sri Tingpong Konyak can claim the land by encroachment. I therefore uphold a special permit issued by the erstwhile additional deputy commissioner Mon, and further allowed Sri Nokman Konyak, that is the present petitioner, son of late Wangshu Konyak, to cultivate the whole plot of land as allotted to his father under the present care of Sri Zani Konyak, who is closely related to Sri Wangshu Konyak and resides at Tizit headquarters. Since Sri Nokman Konyak is reading in school at Mon, but in no case Sri Zani K can claim ownership of the land. Also, Sri Nokzam Konyak and Sri Tingpong K should stop encroaching the said plot of land immediately in order to avoid further complications. So this clarifies the whole issue. The present respondent, he is not even a necessary party here, Your Lordship. He is not even proper party in this case. They did not challenge this memorandum. His father did not challenge this memorandum, Your Lordship.
Lordship,
And
may,
now he is bringing in new issues and trying to complicate the matter.
Lordship, may kindly see the second paragraph. Here also to cultivate.
Yes, whatever it may be, Your Lordship, whatever it may be, whether to cultivate or whatever, but his father tried to encroach. The present respondent's father tried to encroach on the land. The district administration said, no, you have no right, and he was kicked out. And if he was aggrieved, he ought to have challenged this memorandum at that point of time. Now the son is coming forward saying that I didn't know anything. we were not informed. This kind of arguments before this honorable court, it is unreasonable. He is not even a necessary party. He is not even proper party in this case. He has injected himself into the case. And this honorable court at least was gracious enough to allow him to submit his case. But he has no case at all. Without him, the matter can be proceeded, and if he has any grievance against the government, let him take the grievance with the government, but not before this honorable court when the petitioner's right is being asserted for a plot of land which he has no right. That was way back in 1975, Your Lordship. They never challenged this order, memorandum.
There was an order including.
Yes,
Yes,
the
the court has allowed.
yes, responded, yes.
But thereafter, it appears that the course title has not yet been amended.
It was corrected, amended, Your Lordship.
Amended?
Amended, yes.
Okay, okay.
We have amended the petition. It was amended.
It was amended.
Yes, Your Lordship, it was amended, yes.
The order is there, but
Yes.
then in the course title, it's only up to respondent number 4.
We submitted the,
It has, yeah, submitted the
yes,
amended course title.
yes.
So, okay, okay,
Yes, Your Lordship.
right. In the 88, it is there.
Yes. So he injected himself into this, and this honorable court was at least gracious enough to allow him to submit his case. Now he is bringing a case which is different from the present issue. That alone, that compensated plot of land measuring 1,200 was done only in the year 1978. Prior to that, the petitioner was allotted the land, which was donated in 1968, way back in 1968 by the different villages, not only his village. So many villages, they came together and donated initially a specific area from where the present petitioner's father was allotted land. And now he is trying to conflate his subsequent allotment and the earlier allotment as one and the same allotment. That is these are issues which are irrelevant to the instant case, Your Lordship.
If I may, I'll be allowed to conclude my argument on this line.
Yes, please. Yes, please.
Firstly, whether the petitioner, by virtue of the special permit that was given to his late father way back in 1971, he can inherit that special permit, Lordship. Because this is not an allotment. Now, the letter of the Chief Secretary, page 42. Letter dated 18 July 1996, Annexure F of the Repetition Lordship. Whether the Chief Secretary has authority to convert the special permit into an allotment. Page 42. The original copy is at page 40, Lordship, page 40, Annexure F. The letter of the Chief Secretary, Lordship, which I've relied upon before.
Okay.
This,
So
this letter,
whether the chief secretary can allow.
yes, can convert the special permit into a patah. Whether there has been a patah issued to the petitioner to this effect. And lastly, Lordship, on the disputed question of facts.
Well, this is a conversion of the permit into
Pata. Apparently.
by this.
Yes.
Hmm.
Because the language says, given to his father and inherited by him. Given. Now, Lordship, the impugned order letter that has been challenged in the writ petition is not a final order. Because the Deputy Commissioner Mon was directed. Annexure,
Which one?
Annexure Q, page 81, Lordship. The impugned letter that is under challenge. Page 81 of the writ petition, Lordship. Annexure Q. This is 25th January 2020.
Page 81.
One of the writ petition, Lordship. 81.
81.
Yes.
81 is special permit.
No. Lordship, in the writ petition, 88, writ petition 88, Lordship. Lordship is
Yes.
calling. Yes.
Page
81, 81.
81 is there.
Yes. Annexure Q.
Q. Annexure Q is regarding special permit.
Yes. The
for
letter,
farmland.
Home Department, Lordship. Government of Ghana, Home Department.
Home Department, yes, addressed to the Deputy Commissioner.
Yes.
Hmm.
Subject is regarding special permit for
Yes.
farmland at
Yes.
Tizit.
Hmm.
Now, this letter, Lordship, may kindly, the observation made by the Principal Secretary, Home,
Hmm.
Lordship, may kindly come to page 83. This is not a final order. I don't know how the petitioner is aggrieved by this,
Just a minute. Okay.
because inquiry is going on. Lordship, may kindly come to page 83.
83.
Yes, serial number 8. Yes. Lordship has found.
Yes.
The other points are the observation made by the
Okay.
Principal Secretary.
Hmm.
8. You may take immediate step for taking action on all the points as mentioned above, the 7 points, and a report regarding the same may be submitted to the office at the earliest. So, not yet finally decided. This was after the repetition the order, which my learned friend has relied upon. No, so that's why. Well, let the Deputy Commissioner submit his report. Whatever observation has been made, they are saying this is an observation. So that's my humble submission, Lordship.
Your Lordship, like I said, the present respondent has no standing in this case. He is not even a proper party or a necessary party.
Hmm. Just a minute. Yes. Hmm.
Yes, Your Lordship.
Hmm.
So the present private respondent number 5, he is neither a necessary party nor a proper party in this instant case to raise in any issue before this honorable court. Way back in 1975, he tried to encroach his father, that is, his father tried to encroach on the land which was held by the petitioner's father. The government said, no, you have no right, and he was driven out by the memorandum. Had he been
By which order?
by the page
Which order it was?
page 34, Your Lordship, page 34.
Okay.
35 is a type copy, Your Lordship. It is 11th April 1975.
Mm.
The then circle officer upheld the
Mm.
land granted to the petitioner's father, and at the same time held that the encroachment by the present respondent number 5's father and another person is illegal, and they were driven away from the land. When the respondent's father himself had refrained from challenging this office memorandum, at that point of time, now to raise that the land belongs to him does not arise. He has no right to take up any issues before this honorable court. Because of that fact, he was not made a party, but he himself injected himself as a.
So according to you that he has been driven once and then now.
Yes, and he never questioned.
Unless he challenged this memorandum,
Yes,
he has no rights.
yes. Unless he challenged it. Now it is too late in the day, it has become final. Now, how many years have passed since 1975? 40 years now. And the affidavit he has filed, it is the facts which are laid down in the affidavit are regarding land which was subsequently donated, not this particular land. It is obvious from the record.
These are disputed question of facts.
If they say it is disputed question of fact, then it is for them to raise it before the appropriate civil court against the government. If they have any grievance, it is not against the present petitioner. He has no grievance against the present petitioner. His grievance will be against the state respondents only, in this case.
Yes. Mm.
Now, Your Lordship, if Your Lordship will go to the special permit for farmland at Digit. That is page 32, 31. 31. This is 29 March 1971. This was passed by the then additional deputy commissioner who subsequently
Became the chief secretary.
became the chief secretary, and he knows the facts of the case. Under what circumstances this land was given to the petitioner's father.
Mm.
This is in recognition of the petitioner's father's contribution during those days when the state was having so many problems. The petitioner's father was an RCM at that point of time. So he shouldered most of the problems and assisted the then district administration. Based on this
So what is the full form of RCM?
Regional council member.
regional council member. Nowadays, that
We have
body has been
bef-
abolished.
before we have this Area Council Act.
Yes,
So under the Area Council Act, we have the regional council members. Area council members or regional council members?
yes, regional council members. It was through the initiative of the petitioner's father that the digit circle could be established. And because of this special assistance given to the in recognition
So
of
this
his.
regional council member, earlier it was known as the area council member.
There are
No,
no this.
in those days, it was called regional council members.
Okay,
But it subsequently was abolished.
okay,
But it
Because
was, yes. it
Tuing
was-
Sang Mon, they were all under NEFA.
that is why.
Yes. Now, after the creation of the state, 1963, the Tuing Sang Mon, they all came under Nagaland State. Earlier, before the statehood of Nagaland, it was under NEFA, Northeast Frontier Agency,
Mhm.
which forms a part of the Arunachal also.
Yes, yes.
And those days.
Arunachal was Nepal. only?
Yes,
Yes,
NEFA,
yes.
yes. So Tuing Sang Mon, they were all
yeah,
under
they
NEFA.
were- they-
Under Nepal, okay.
So,
They all were together,
We all together.
yeah.
okay.
So this was passed. 1975, it was affirmed. Then in 1996, the chief secretary himself has written this, and the chief secretary clearly lays down the parameter of the inquiry to be conducted. It is not that it has to be conducted on the in accordance with what is laid down in the chief secretary's order.
Principal Secretary. Abhijit, no, he's Principal Secretary.
Yes, page
42.
42, yes. So this clearly lays down the parameters of the inquiry. It is an undisputed question that the land has been allotted to petitioner's father, it should be protected. And without his consent, no land can be allotted by the administration. That is clearly written by the chief secretary. If your lordship will allow me to read. A representation has been submitted to me by L. Nokman Wangshu, son of late Loktan Wangshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. His special permit for farmland at Dizit was given to late Loktan Wangshu, the then RCM, and the area given to him was properly delineated in course of time. Encroachments had taken place by police department, industry department, and also by private individuals, though permits given by administration at different times. The land given to late Loktan Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. It appears that no respect was shown to the permit holder who was given the farmland by administration for recognition of his services given to the government and the people. Even the ounce of disease area had consented to this, as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people. Instead of protecting the privileges given to certain distinguished persons, if the administration allows encroachment by individuals or government departments, it does not show any good images before the public. You are hereby asked to conduct special inquiry and submit detailed report comment as early as possible. This inquiry is to ascertain the extent of encroachments. How much land has been encroached without the knowledge of the petitioner? And to submit a report so that the office of the chief secretary can take a decision thereon. Not to take away the land from the petitioner. It is very clear. It is to protect the petitioner's right that this inquiry was being conducted, Your Lordship. Now, this honorable court's judgment and order also is very clear. Page 50, so the effective paragraph, page 52, paragraph 5. The inquiry is to be conducted only, yes,
Page 52.
yes, page 52, the relevant paragraph is paragraph 5, Your Lordship.
Just a minute.
This,
Okay.
This is the clear observation of this honorable court. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum on 11/4/1975. That is that memorandum which I was referring about the present respondent number 5's father being kicked out and upholding the earlier allotment, recognizing the same. If there is any encroachment, definitely this is prejudicial to his legal and constitutional right, Your Lordship. If there is any encroachment, it is prejudicial to his legal and constitutional right. The Chief Secretary of the State, being aware of the situation, issued direction to the jurisdictional Deputy Commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold a special inquiry as directed by the Chief Secretary. Although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible, but the proceeding went hibernating without any valid reasons, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the Chief Administrator of the state has been stopped. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potentials of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic setup of governance. 6. This is very important. Although an affidavit in opposition has been filed on behalf of official respondents, so official respondents have filed affidavit in reply, claim of the writ petitioner has not been disputed, Your Lordship. So this judgment and order has become final, Your Lordship. In the affidavit, whatever claim was made by the petitioner, it is not disputed. So the inquiry is to be conducted only in terms of this judgment and order, and also the earlier order passed by the Chief Secretary. Parameters are clearly laid down, Your Lordship. Scope. It cannot go beyond that. Inquiry, what was the extent of encroachments? Only that report is required by the Chief Secretary. None other. But what happened? By the impugned inquiry, they started making proposals, which is contrary to this, to the judgment and order, and also the Chief Secretary's letter, recommending that only a portion which is now being occupied by the petitioner as his residence, that should be given. The entire land should be taken away.
By impugned order.
Yes, by the impugned order. This special inquiry, annexure K, page 54. Here, everything. Your Lordship may come to page 62. This is the first inquiry report, which was submitted by the additional Deputy Commissioner.
62 is the first.
Yes,
inquiry report.
page 54. Page 54 is the forwarding letter. That is annexure K1. Then the report follows from page 55. Special inquiry report. If I may start reading from page 55, Your Lordship. Background. What is the background? They have also laid down all the facts as is laid down in the petition only. Then what you. In 1971, the then ADC Mon issued a special permit to let L. Wangshu as farm land in recognition of his services given to the government and the people. White office memo number so and so, dated 1971, dated 29 March. In 1974, Sri Let L. Wangshu died, and the special permission passed on to Sri Lokman Wangshu, the eldest son of Let L. Wangshu. Sri Lokman Wangshu alleges that despite having documentary evidences, the general administration has several times encroached upon his legally inherited farmland by way of issuing permits without his consent. In the same manner, in course of time, government departments, including industries, other private individuals were granted permit by the general administration. So now, committee findings, Your Lordship, page 57. These are the findings. One, the special permit issued in 1971, white memo number so and so, dated Mon, the 29 March 1971, issued by the then ADC Mon is authentic. However, there is no record of payment of revenue to the government, and the permit does not stipulate any terms and conditions governing the special permit. Number two, it is an accepted fact that the land for district headquarters town was donated by Chapoka village to the government, and the special permit itself was issued to let L. Wangshu by the government in view of the rapidly growing population of district town. The district administration needs more land for development of the town to appease the growing needs of land for dwelling units. The district administration have issued permits for the purpose of expansion and development of the town. Three, there are already 111 numbers of permits issued by district administration from 1988 till date. Further, 12 numbers of plots were settled through the complainant and 17 numbers without any permission, adding up to 140 families already settled in the area. Trying to relocate these 140 odd families will create a lot of social tension, leading to a grievous law and order problem in the town. Four, the committee is of the view that to bring an immediate and amicable settlement to this issue, an alternative arrangement may be offered to Shri Lokman Wangshu by offering him 200/300 square feet of land presently occupied by him, and also in recognition of the services rendered by his father, late L. Wangshu, either a school or public hall in the locality be named after him. See.
So this is impugned.
Yes,
This is impugned.
this is also impugned, yes. Because it is not in accordance with this honorable court's judgment and order, and also not in accordance with the chief secretary's direction. Then
Any other or you are
That-
impugned by this order?
no, there are also subsequent impugned orders.
Okay.
In the earlier two petitions, I'll come to the impugned orders. But in this 88, the main impugned orders are to be,
Because I'm only in 88, Lordship.
yes,
Okay.
I'm not
Yes,
in the other
yes.
case. So if the 88 is completed,
Yes.
Lordship, if I may be allowed to proceed because I have
okay.
a
Okay.
fixed matter.
Page 81, Your Worship. This is the Government of Nagaland Home Department, General Administration, Branch 1. This is another one, Your Worship.
This page 61.
Yes, page 81, Your Worship. Annexure Q. The one which was pointed out by the learned counsel for the private respondent number 5.
81 is,
This is also in complete, completely contrary to this honorable court's order and the chief secretary's direction.
this is.
This is issued-
The
this is-
earlier impugned order was this.
earlier,
On which
impugned
date?
order was a special inquiry report.
2014.
Yes,
And then this is 2018.
yes, this is 2008.
You are impugning this order also.
Yes, October 2014, this October 2014, and then subsequently, based on this, they have in their affidavit,
Page October, which one?
the first impugned
Yes, yes.
inquiry report is dated 31st October 2014. This was an inquiry conducted in pursuance of this honorable court's judgment and order.
October. Yes, 31st October.
Yes,
This
this
is
is
for-
this is a report based on the direction of this honorable court.
This is special inquiry report you are
Yes,
challenging.
which I am, yes, because it is not in accordance with the chief secretary's direction and this honorable court's judgment and order. And then
It is not in accordance with,
with the chief secretary's direct order to the district administration and the direction of this honorable court in the WPC 204K of 2012. Judgment and order dated 5/8/2014.
okay,
My contention is that whatever inquiry is conducted and whatever final order is passed, it should be in accordance with the chief secretary's order issued in 1996 and this honorable court's judgment and order. It should not go beyond that. It should proceed in accordance with this direction only, and then ultimately any decision taken should be based on on these two directions. If it goes beyond that scope, then it is illegal. That is my position, Your Lordship.
yes,
Page 81, Your Lordship, this is another impugned letter, Your Lordship. Now, why, whether it is in consonance with the chief secretary's order and this honorable court's order or not will come out from a reading of this, Your Lordship.
Hmm.
If I may read.
Hmm.
Regarding special permit, this is dated 26th of January 2020.
yes,
Sir, please refer to the subject cited above and the letter number so and so dated 1st February 2020 from ADC Digit addressed to you with regard to the status of the entire land under the special permit as it existed on date, copy enclosed. And another letter number so and so dated 6th of January 2020 from ADC Digit addressed to you, mentioning the meeting with Sri L. Nokman Wanchu Kongyak for settlement of the entire dispute concerning the aforesaid land. 2. The detailed report of ADC Digit of the land under the special report showed that out of the 157.81 acres of land, initially Sri L. Nokman Konyak has over a decade sold given 91.0195 acres of land to various individuals, organizations, which is about 60% of the total land. The area of the land which is allotted to private individuals, organizations by the office of ADC Digit is 42.4314 acres. The land utilized for government department offices and for roads and other public utilities like drains is just 16.928 acres. The report also mentions that after resurvey, the land under actual possession of Sri L. Nokman Wangshu Konyak, his residence and fishery bond is 0.67 acres and not 5.1 acres as reported earlier. The report stated that the vacant land behind the house of Sri L. Nokman Wangshu Konyak, which was allotted to 12 private individuals by IDC Digit in 2012, and which is being asked now by Sri L. Nokman Wangshu Konyak for settlement, covers an area of 4.43 acres. 3. It is thus clear that Sri L. Nokman Wangshu Konyak has over the years already disposed of a substantial portion of the land under the special permit, which was given to his late father for cultivation purposes only, by giving selling to many private individuals, organizations, without any intimation or consent of the government. Hence, it will not be proper to consider allotting any more land to Sri L. Nokman Konyak. The ADC Digit may accordingly be asked to convey the same to Sri L. Nokman Konyak. 4. As recommended in the Special Inquiry Report of 2014 by a committee headed by ADC Digit, copy enclosed, you may make allotment to Sri L. Nokman Konyak only for the land measuring 0.67 acres, which is under his actual possession. Further, as also recommended in recognition of the services rendered by the late father of Sri L. Nokman Konyak, ADC Digit, may be asked to take concrete steps in the direction of getting a school or public hall in the locality named after Sri L. Wangshu Konya. 5. Further, in public interest and taking into account the present circumstances as it exists in Digit Town, all the vacant plot tracts of land falling under a special permit need to be kept for use by any government office or for taking up any developmental activity that may come up in future. Hence, you may take immediate steps for cancelling the allotments covering an area of 4.43 acres to 12 private individuals made by ADC Digit in the year 2012, which is a consolidated tract of land at one place and mentioned at serial number 4 in the report of ADC Digit dated 1st of February 2020 and take under the custody of the government. 6. The vacant plots not sold given to private individuals by Sri L. Nokman Wangshu Konya or allotted through any permit by ADC Digit, as well as those plots sold given to private individuals by Sri L. Nokman Wangshu Konya but vacant mentioned at serial number 10 and 8 in the report of ADC Digit, there is so and so, which measures 7.674 acres. So and so may also be taken over by the government. In all these cases, proper allotment orders in the manner as considered appropriate by you may be made so that there is absolute clarity that these tracts of land belong to government. 7. As regards the land already allotted to private individuals by Sri L. Nokman Wangshu Konyak and which are not vacant, with some constructions done or some development of the land done in some manner, and for which permits have not been given by ADC Digit, as mentioned at serial number 6 of the detailed report from ADC Digit, dated 1st of February 2020, you may prepare a proposal and submit to this office for regularizing such allotments by getting permits issued by ADC Digit. Action on similar lines may also be taken for an area of land, so and so acres, which is not vacant and over the years have not occupied by private individuals, organizations without being allotted by ADC Digit or being sold given by Sri L. Nokman Wangshu Konyak as mentioned at serial number 9 of the report dated 1st of February 2020. 8. You may take immediate steps for taking action on all the points as mentioned above, and a report regarding the same may be submitted to this office at the earliest. So this contradicts the judgment and the Chief Secretary's letter. The Chief Secretary is very clear. It is a special allotment given to the petitioner. It should not be taken away from him. If any encroachments are there, conduct inquiry and submit a report. This court has also held the same. Go by the Chief Secretary's direction. So any decision has to be taken in accordance with the Chief Secretary's order and also the direction of this Honorable Court. It cannot metastasize into all other areas. The Chief Secretary has clearly said it is his land. Now we have given him. Now the subsequent officers are saying no, he has allotted land without the permission of the government. Chief Secretary's letter says that it is the government cannot allot any land or take away any plot of land without his permission, the petitioner's permission. Whereas the subsequent reports are saying that the government has made valid allotments, whereas the petitioner has made allotments without the permission of the state.
Oh, by the way, what about the land allotted by the government in the meantime? Have you challenged those orders?
Yes, those were the orders that has been challenged, and here in this my prayer is that in my prayer itself it is very clear, Your Lordship.
Have you annexed allotment order?
I am only
No.
no, Your Lordship, I am not challenging for questioning those aside.
Okay,
I am saying that whatever allotments was made by the government, it should be compensated. That is my only point.
okay.
That is my only point here. But Your Lordship may also pass an appropriate order to the extent that these subsequent orders and the inquiry reports and impute letters are not in accordance with the clear direction of the Chief Secretary, letter dated 1996, and the judgment and order of this Honorable Court. So there are questions set aside. However, the government must take action in accordance with the direction of this Honorable Court and also the chief secretary's letter. Any decision that is taken must be in accordance with that. Now, till the direction of this, the judgment of this honorable court has attained finality. The government has not challenged it. The government, in fact, on the basis of their admission that this honorable court has passed a judgment and order. Now, your lordship, I'll just take your lordship to one judgment of the honorable court, where of the honorable Supreme Court, where the honorable Supreme Court has laid down where statutory provisions lays down a certain thing to be done in a certain manner, it must be done in that manner and nothing else. But here, the law is the judgment of this honorable court and the thesis order. So whatever has been clearly specified in the thesis order and this honorable court's judgment, it has to be followed in that line and no other. That is my only an analogous position I would like to submit before your, because this principle will also apply here, Your Lordship. This is 2011 10 SCC, Your Lordship. 10 SCC. 714. Relevant paragraph, Your Lordship. Paragraph 32 only, Your Lordship, page 725, Your Lordship.
Paragraph 30.
Paragraph 32.
Hmm.
It's just an analogy I'm bringing before this honorable court. It is settled law that when any statutory provision provides a particular manner for doing a particular act, the said thing or act must be done in accordance with the manner prescribed, therefore, in the act. Merely because the parties concerned were aware of the acquisition proceedings or served with individual notices does not make the position alter when the statute makes it very clear that all the procedures must have to be strictly complied with in the manner provided therein. So here, the judgment has become final. The court has given specific direction. Go by the direction of the chief secretary and protect the rights of the petitioner. So it has to go, any inquiry has to be conducted in that line, and any action taken should be taken within the parameters that has been laid down. It cannot, no extras can be added, Your Lordship. Otherwise, any authority can just make their own decision along the way. This is why the petitioner has also subsequently submitted a representation after this impugned letter was issued. Let an amicable settlement be taken up. I am willing also to accommodate the government since so many allotments have been made. But instead of acceding to the petitioner's requests and demands, they have arbitrarily taken this decision, take away everything, rename, let us name one school or some community hall as the petitioner's in the petitioner's father's name. That will suffice his services to the state, the Lordship, and leave the petitioner and his family with empty stomachs. It's not going to help the petitioner's family by naming a school when his entire livelihood is taken away from him. It should be reasonable, Your Lordship.
So according to you,
Yes.
while referring to this
Yes,
The statutory, it has to be as per the chief secretary
yes.
letter or
Mm.
the order. And then in no any, it has to be in the manner
Yes,
as decided by the chief secretary
Chief Secretary and the direction of this honorable court.
and the direction of this one.
Yes, that is very important. This honorable court, this honorable court did not take the decision in a vacuum. The government came forward saying that the statements of the petitioners are correct.
Okay,
So based on that, this honorable court issued the direction, not an arbitrary one. So now the government cannot go back on its word. If they were agreed, they ought to have challenged the judgment of this honorable court. But now it has attained finality. So once it is final, it has to go by the direction of the findings of the court. No new things can be added by the government along the way. Otherwise, it will lead to injustice. That is my position. Now, in the other two cases, Your Lordship, these are. I have.
I will take a leave.
Okay.
Since
Okay.
I'm only
Okay.
in 88, Lordship, I'm not in other
Okay.
two cases.
okay.
Obliged, Lordship.
My judgment is confined only, my case in all these are confined only to this.
So where is your, this is in, what is the difference between this
And,
88 and
uh,
55?
When this inquiry was being conducted, impute orders were issued by the head Tobashes directing certain persons to whom the petitioner has allotted some land for constructing temporary
Hmm.
buildings to allow them to stay there for their children's education. Several persons were allowed to construct some temporary thatched buildings
By the petitioner, by the petitioner.
Yes, this is a social act
Hmm.
on his part.
Hmm.
He has not sold it. He allowed them to stay on the land because their children's education are being taken up in the town itself.
Hmm.
So these people were directed to vacate by the head Tobashi.
Hmm.
So
Head Dabas is not
head
party here.
Tobashi, no, and head Tobashi, they are this Tobashi's court and all, they are deemed to be also a court, Your Lordship. So and
That has been
yes,
challenged.
no, yes, they fall under the ADC.
Okay, so this is in
are under the
58, this is in
ADC.
which WPC?
This is in WPC 207 of 2016, another one,
Okay,
yes. The impute orders are.
have you submitted the list of date for the year? Brief
Yes.
written submission in all these cases
In-
separately?
Yes, yes, in my written submission, Your Lordship, I have
No, have you submitted written submission in
Yes.
88?
all three, I have clearly delineated
okay, yes.
if Your Lordship may go through it.
Okay, in on.
Yes.
Okay,
So one petitioner's case in the three writ petitions. Three facts common to all three writ petitions. What is the fact common to all three writ petitions? I have clearly laid down. Then pre-facts particular to the WPC 207K of 2016.
hmm,
There are two orders which are imbued here, Your Lordship. And then pre-facts particular to WPC 58K of 2017, Your Lordship.
what is this impugn order?
Yes.
The impugn order in 207?
207 is. These are orders issued by the ADC and his subordinates, all these orders.
15-1 and
Yes.
2015.
2000 in WPC 207 of,
The impugn order is 15-1 2015.
yes, 15-1, 2015. and impugned restraint order dated 15/1/2015 and 12/10/2016, ordering not to carry out any development works in the land in question by any individuals or groups until final settlement by the court. In fact, this court had already disposed of the judgment by then, but hiding behind,
Your contention is same,
yes, here I am saying that these orders were passed in contravention of this honorable court's direction, earlier direction, and also,
and it appears that separate order need to be passed in this 207 also.
your lordship, even if separate order is passed also, it is okay. But if they are also, because the foundation of the case is same in all.
Same.
Yes, foundation is same. The foundation is allotment, first allotment. It being upheld in 1975, the deputy commissioner's letter and the order of this honorable court.
So restraint order was passed by additional deputy commissioner only.
Yes.
This it appears,
Here.
not by
yes,
the Dobasis.
Yes, then the vacation order was issued by the head Tobashi.
Okay, subsequently or
Yes, yes,
prior to
yes.
that.
Yes, sir. Then again, in the
No,
2000.
what is this January 15 and then what is this October? 12 October.
12. then
Restraint order.
Restraint order, yes.
Restraint order was
Yes,
was
yes.
also issued by additional deputy commissioner.
Additional
only.
deputy commissioner, if I'm not mistaken, your lordship, 207, na? 207.
12 October 2016. First one is also restraint order only.
Yes, this is first one and the second one, they are,
Okay, vacation order was
It's
issued by
restraint
head
order.
Dobasis.
yes, and vacation order was issued by the TV, your lordship.
Yes,
Tobashi.
so this was 2016.
2016. So against this, I filed this writ petition.
So this ADC has issued this impugned order dated 15 January 2015 was
Yes.
issued based on what?
He is saying WPC 204K of 2012, dated Kohima 7 August 2014, in connection with land dispute at industrial colony, it is hereby ordered not to carry out any developmental work. No such order was there, your lordship.
Now, what is this WPC 204?
In fact, the WPC 204 is that judgment of this honorable court, your lordship. That is the only case which was filed.
Okay,
Yes.
okay, this 204 was in your favor only.
Yes, in my favor only. So when the judgment is already there, that court has directed that inquiry be conducted.
No, this restraint order is for against whom?
Restraint order is against those persons to whom, against, it is a general order, but it applies to the present petitioner.
No, general order applies to the present petitioner also.
Yes,
No, because it was this 204 was the order, that order was in your favor only.
yes, in my favor.
But then why
Yeah.
it should be?
It is a very general kind of order. It was also, I was also directed not to do anything.
No, it was order issued. It should have been order issued to all others except you. It should
Yes.
have been.
Yes, but it includes the petitioner also. It is very general. This was also issued against me.
Because while referring to the order dated, order
Yes.
the order passed in WPC number 204, it should have been
It should have been, yes,
have been
yes, but
against all other by protecting you.
yes. Say, number 4, your lordship, copy to, if your lordship should come to copy to page 35,
Knockman Wangso.
yes. Even I am restrained by this order. By this,
How do you interpret that way? Because this WPC 204
Yes.
is in your favor.
yes, it is in my.
When pursuant to the order and direction in 204, it should have been, it is assumed that it is
Yes,
in order to protect your right,
yes,
because the High Court has
yes. your
protected
lordship.
you.
Yes,
So this should have been information to you that they are issuing the restraint order in against all other except you. It should have been.
yes.
How do you
Your lordship.
interpret it otherwise?
Let me just see the statement in the,
There is any report based on which this order was restraint order was passed?
No, Your Lordship.
There is any complaint based on,
No,
no complaint also?
no complaint. It is a general order, and this copy was given to the petitioner and P. Honai Konyak, let me see that.
So. So these talk about which final settlement of the case by the court, which court? This order refer?
They are referring that, I was told that writ petition is still, it has been issued as if the writ petition is still pending disposal.
Yes.
Yes. It is a very difficult.
There was
No.
no
I-
case,
Yes, by then the writ petition.
no any litigation was pending against
No,
them.
no.
Okay, but then this order was issued.
Yes. but
Have
this is-
you clarified this in your writ petition?
In my writ petition, I have in paragraph 7, if your lordship may come to paragraph 7,
Hmm.
page 9. This petition was filed by my friend,
Hmm.
uh, who is now no longer in practice, so the petitioner has approached me. So this is a specific paragraph 7. That the petitioner most respectfully begged to state that having not satisfied with the findings of the special committee report, the district administration and the petitioner had meeting on 10/7/15 and 31/7/2015. And the report of the said meetings were submitted to the Deputy Commissioner Mon, dated 2/9/2015. Mention may also be made that to utter surprise, the additional Deputy Commissioner Digit issuing the restraining order dated 15/1/2015 and 12/10/2016 in total contravention with the finding of the special committee report, wherein the ADC Mon, he himself was the chairman of the special committee. Further, in the impugned restraining order, it is stated as follows, with reference to this office order number so and so dated 15 January 2015 in connection with High Court case at Industrial Colony Digit Town. It is once again notified not to carry out any developmental works in the said dispute area by any individuals or groups until the final settlement of the case by the Gauhati High Court Kohima bench. Failing to comply with this order will tantamount to contempt of High Court order dated 7th August 2014, liable for legal action. Meaning thereby the administration had issued the impugned restraint order dated so and so under the impression that the writ petition is still pending disposal before this honorable court. Whereas in fact, the case had already been disposed of by this honorable court wide judgment and order dated 5/8/2014 in favor of the petitioner. And as such, the impugned restraint order are liable to be quashed and set aside in the interest and for the ends of justice. That is the.
Okay, so
And then.
this was under the impression that the case
Yes,
was
yes,
still under,
was still.
still pending disposal.
Yes,
So that is why this order was issued.
yes, you're right.
Otherwise, there is no complaint.
Yes,
And restraint order subsequently it was issued on 12 October. Is it same?
yes, then 12 October, well,
It's
yes.
a reiteration of the
Yes,
same.
yes, it's a reiteration of the same. And then the vacation order. This vacation order is against 7 persons who were allowed to make some temporary orders for stay of their children during their schooling. So these people were directed
So
to vacate. So I have approached, since it is
no,
not.
unless someone complain, how it becomes a disputed land? If there was no any complaint,
Yes,
they are terming it as the disputed land.
yes, they just blindly are issuing this order, your lordship, orders, your lordship.
Okay, so the administration has taken it as suo motu action.
Yes, no motu action, your lordship. No complainants are mentioned here, your lordship.
So who is respondent here in this case?
In this case, the,
Government is still there.
yes, government,
And
how to
then,
head Tobashi.
head overseas
Head
is
Tobashi is also made. The head Tobashi has no authority, no authority whatsoever even to
No,
issue
no,
this. They have no
this-
jurisdiction. But
Respondent number 5,
yes,
functioning in the capacity of the court,
yes,
probably cannot be made as a party.
yes, but he is not acting, he is only issuing it as office of the, in the name of the additional deputy commissioner.
Oh, can that be?
No. They are
Then-
saying
then
in the
this-
court
this
of
other-
TBs, office of the additional deputy commissioner, but the TBs are a group of people who sit in our court. But here that
He's,
the head TB is himself.
this is an administrative order
Yeah, this is an administrative order in the guise of a court
without any authority.
without any authority.
Whether they are also employee of the,
These Tobashis, they are, I believe the origin is, they were initially appointed during the British days as in Hindi, do bhasha, that means someone who can speak two languages, they were,
Do bhasha.
yes, they were
who knows two languages
yes,
to interpret.
yes, they were interpreters.
Ah.
Then slowly.
Oh, that is why, yes.
Yes,
Dobasi.
then later on,
It was very difficult to pronounce. Now I could understand.
yes,
What is Dobasi,
Yes.
the meaning of Dobasi in
yes,
Naga?
it comes from the,
It came from
Hindi.
that Dobasa.
Yes,
So Dobasis.
it comes from the Hindi,
Got it.
but it has now been
Thank you.
changed slightly in the Naga country.
But somewhere it Dabasis again.
Yes.
Dabasi, Dobasi. No one is sure about the spelling
Yes.
also.
So later on, under the 1937 rules, through amendments, they are given some judicial power, but they cannot take up any case which
Yes,
is
yes,
not referred
yes,
to them.
Okay, here, but there is no private respondent as a.
No private respondent.
Okay,
Then,
so this is with regard to 207.
yes, 207,
Okay.
that is the one, and with regard to 58 of 2017. In the agreement. Yes, come on in order, yes. Now. Annexure G and G1. Here, a complaint was received from the respondent number 6, Your Worship. Respondent number 6, that is a Monian Union, Your Worship. Yes,
Yes. Yes. Very good. Let's see, yes. Okay. Yes, here you have challenged.
Yes, page 39, Your Lordship, annexure G.
Here the
and-
complaint was received from the respondent number
Yes,
6,
yes, respondent number 6, that is the Monian Union.
Morning Union.
Yes,
Who is this Morning Union?
Monian, it's a union, it's a union of a group of,
This group
Person.
consists of?
I believe it belongs to a particular village, maybe, because we have unions in the villagers, people belonging to the same village, they form unions in the towns. So it is that kind of a union. So this is issued by the head TV, Your Lordship.
Impugn otherwise issued by head DB.
Head TV, Your Lordship. A complaint letter have been received from Sri Zanai President and K. Abang General Secretary on behalf of Monian Union District Town on 23rd March 2017 against Mr. Wangtun Konyak of Nitong Village. He is a missionary, Your Lordship.
Hmm.
So this person was allotted a small portion to construct as residence. He had already constructed one thatch house there. He
In
was
your-
already staying there,
in your
by me, yes. So this union,
Allotted by you.
yes, allotted by me.
Okay.
So he had already constructed one building over there. Now this Monian Union, they are claiming that they were allotted land by the district administration, and so he should vacate. That was that is their case.
Okay, they were allotted by the district
That
administration.
is what they are claiming.
And then the present person
Yes,
allotted by you,
by me.
allowed by you,
Yes.
he encroaches their land or what?
No. They are claiming the exact place where
Okay,
he
Okay,
is.
okay.
He has constructed his residence.
he's
as
allotted
land
to them
allotted
by
to
this.
them.
Okay.
So they want him
that
to
means that
vacate.
means the land was not under their possession after
No.
allotment.
Okay.
Okay,
It was already under the possession of the petitioner, and also it was occupied by this Mr. Wangtun Konya.
okay.
It is a thatch building.
So this group consists of how many persons?
Your Lordship, I have no idea.
So complaint was lodged by,
Respondent-
complaint was, where is the complaint? Can you just give us?
That later complaint later is not here. Only this summon is here, Your Lordship. But
Complaint
but-
letter, later on also you did not procure the complaint letter?
no, Your Lordship. But it is. Miss Abila is here, Your Lordship.
Lordship, may I please, Your Lordship? I'm appearing for respondent number 6, Lordship, for the Mongolian Union, Lordship, in read petition 58, Lordship. Lordship, Union, I will come to my submission part also, but just to apprise that Union comprises of more than 10 villages under the district subdivision, Lordship. So more than 10 villages clustered together and form the Union, Lordship.
Your respondent number, have you filed affidavit?
Yes. She has filed affidavit.
Lordship, my affidavit dated 28 April 2023, Lordship.
Affidavit is filed by one, and then
Affidavit.
Respondent number 6, Lordship, file on 2023, Lordship.
He has annexed a government permit, Your Lordship.
yes, what is your grievance?
My grievance is.
No. So. Yes, Ms. Apila, what is your submission, your contention?
Lordship, my only contention is that the land that is been that the land in question is that the union has been allotted by permit number 121-1106 of 11, dated 15/5/11, Lordship. So in my petition, in my affidavit, I have clearly mentioned that, Lordship, if I may be allowed to read, Lordship, that will make us clear our confusion, Lordship.
Yes,
Lordship, I may be allowed to read, Lordship.
yes, please.
My affidavit dated 28 April 2023, paragraph 5 onwards, Lordship, page number 3, Lordship. That with regard to the statements made at paragraph 8 and 9 of the writ petition, the answering deponent begs to state that a portion of land has been allotted to the Monyan Union Peering Site Permit number digit 110611, dated 15/5/2011, measuring an area of 80 length and 80 breadth feet. That since 15/5/2011, the said plot of land stands under the custody of Monyan Union Digit Town. Mention may be made that somewhere around in 2015, it came to the knowledge of the respondent number 6, that is the Monyan Union, that the land permitted to respondent number 6 was sold by the petitioner to one Mr. Hong Long and subsequently allotted to one Mr. Wong Tong Konyak, as admitted in the petition by the petitioner, wherein some constructions was also took place in the said land. However, upon placing record by the respondent number 6, the said plot of land measuring an area of 80 into 80 stands under the custody of Monyan Union. Subsequently, by order dated so and so dated 25/2/2020, issued by the Additional Deputy Commissioner District Nagaland, a total of 12 permits issued by the area of 4.43 acres were cancelled and taken under the custody of the government. However, there is no such order that cancelled the permit of respondent number 6. Therefore, it is illogical for the petitioner to claim ownership against a said plot of land permitted to Monyan Union, which is never cancelled nor held by any other third party, Lordship. This is my submission, Lordship. And when we come to know that the land is already permitted to Mr. Wong Tong, which is sold off by the petitioner to Mr. Hong Long, we have put a complaint accordingly by Dobashi order dated 13 April 2017. Dobashi court has come to the conclusion that the land still is in the position of Monyan Union. Accordingly, the land in possession was permitted to Monyan Union Lordship.
No, you are talking about the cancellation of the.
Lordship, we were not a party, Lordship. However, the
No, no.
government has.
Have you annexed this order? Or the complaint? Where is your
No,
complaint?
Lordship, no.
You have not annexed.
Lordship, I have not annexed, Lordship. Lordship, I have not annexed, Lordship.
Would
But I
have,
can place
would have annexed.
Lordship, Lord.
You have mentioned about the cancellation of some 12 permits.
Lordship.
That was cancelled by ADC.
ADC, Lordship, ADC, which we were not a party in that or so, but as per the record from the petition, it speaks that there were certain cancellation took place, Lordship. However, in that cancellation also, our permit was not cancelled, Lordship. So we stick to the permit that is issued by the government.
Mr. Pongna, do you have or have you annexed this cancellation order 2025/2/2020? This is also in your lane.
The cancellation of the. No, Your Lordship.
So
Lordship, I have annexed Annexure 2, Lordship, page number 10. 12 permits were cancelled, Lordship, which I have annexed in my affidavit, Lordship. Page number 10, Annexure 2.
okay, with reference to home departments and so.
Yes, this is with regard to other,
With reference to the Home Department.
But the 12 permits falls under the disputed land which is in question, Lordship.
Farm land, Egypt data center. Okay. Although it was cancelled, but while saying that it was permitted to Wangsur, but it has taken into custody of the government by this
that is
order.
what they are saying, yes. But it contradicts the judgment and also the.
Oh, that is why, have you
Yes.
challenged this order? Have you challenged this
Your
order?
Lordship, I am not, because it was still in process. The inquiry was still in process at the time. And I was occupying the land, Your Lordship.
Just see the language.
Yes.
Permitted to covering an area of 7 acres are hereby cancelled and taken under the custody of the government.
Yes.
So
Government.
All these have been mentioned, Your Lordship, in the report also, in the impugned report also, and all these are already mentioned, Your Lordship.
so this is not a part of,
And I'm not concerned with all these things. My concern is that land has been allotted to me. The Chief Secretary has clearly said that it cannot be taken away from me. This court has also directed that.
no, by this
So-
order, the government is taking away.
So that order is illegal, Your Lordship.
This also should have
Ipso
been,
facto.
Lordship,
this,
Lordship, if I may be allowed to speak, this 4.43 acres is also included in the question of the disputed question, the land in question, Lordship. Which the petitioner is claiming, Lordship.
we have not impugned.
No, Your Lordship. If the allotment is found to be without jurisdiction, it is void ab initio, Your Lordship. No matter what kind of allotment is issued, if it is found that it was without jurisdiction, then it's a void order and cannot be enforced.
So your only contention is that since you have been given permit,
Yes,
the
yes. The
respondent,
government, yes.
appealer, you have been given permit.
Responded,
Mm,
Lordship. Lordship.
in the area on the or in the plot where you have been given permission or permit, the petitioner has
Yes,
the same
Lord.
plot, petitioner has sold out to somebody.
yes, petitioner had given it to someone else and he had already
Lordship.
constructed a building there, he was staying there. When this complaint was lodged.
The petitioner has also called out and accordingly, the Dabashi court has called for the hearing, and the Dabashi court has passed the order in favor of me after placing on record the documents, Lordship, which is the permit lord issued by the government, Lordship.
Then this Dobasi, then here, okay, union has been impleted, okay. So Dobasi only protect or pass order in favor of the union.
Yes,
But then Dobasi's, well, functioning is the court cannot be impleted here, it appears.
it was the
Because-
head Tobashi, Office of the Additional Deputy Commissioner District, Your Lordship.
Okay,
Same as before, in fact, it is an administrative order, Your Lordship, it is not judgment
Mhm.
also. It is purely administrative order.
where is the Dobasi's order?
Page 40 again, page 39, summon. Page 39 is a summon, and then page 40 is the order, Your Lordship.
So page 39
Yes,
has been issued in the capacity of head Dobasi.
Yes. And then order has
No,
also.
order
been
also
passed.
is in
Same.
the capacity of head Dobasi only.
Yes, same. This is not a judicial order. This is not a. In fact, it is not a case filed before the court.
So you also appear before the Dobasi.
Yes, yes. The
And then you did not produce your permit before the
no,
Dobasi.
because it was me who was the one who allotted him the land. So his submission was that it belongs to. This is land belonging to the present petitioner. He has allotted me this land and I'm staying here. That is all. He does not need any land permit from
Okay, okay.
anybody.
This complaint was against,
Yes, yes.
no, not against you.
Not against me, against that person there.
Okay, that person is the party here.
That person is not a party.
That person
Because
has not
that
challenged
person-
this order.
That person is staying with my permission. So they came and tried to evict him. Actually, this land is not sold also, Your Lordship. I am allowing these people to stay there on my land.
Someone is issue, someone was
Someone was
issued to
issued
whom?
to him,
Not to you.
not to me. Someone was.
But
issued
you are
to him
challenging this.
Because it is my land and the order, this order ought to have been issued to me. This letter ought to have been issued to me because it is mine. I am under occupation of it. But this order was not even issued to me. They issued this summons to that Mr. Wang Tun, who is staying with my permission.
Where
No,
have you
he-
stated, where have you clarified that? Paragraph 8, Your Lordship. Paragraph 8. If I may read, Your Lordship, that the petitioner most respectfully begs to state There are
that.
8.
Yes, paragraph 8, page 10, Your Lordship, page
Page
10.
10.
Yes.
Okay, start from 9.
That, if I may read, Your
Yes.
Lordship, that the petitioner most respectfully begs to state that on the strength of special permit dated 29/3/1971, petitioner had allotted a small portion of land to one Mr. Wang Tun Konyak missionary, and accordingly, Mr. Wang Tun Konyak had constructed temporary kacha house over the said land, and till date, he is residing in the same building. However, to utter surprise, the so-called Monian Union did in claiming that state site is allotted to their union on 15/5/2011 by the administration. Therefore, in the light of which Monian Union had lodged a complaint before the authority concerned, consequent upon which summon letter dated 10/4/2017 was issued by the head TV, calling upon Mr. Wang Tun Konyak and Monian Union to appear before the TV's court on 13/4/2017 at 11 a.m. Accordingly, both the parties appeared before the TV's court hereof. Mr. Wang Tun Konyak missionary fairly stated that having seen my pathetic condition, petitioner had allotted a small portion of land to construct a temporary building within the special permit. On the other hand, Monian Union produced a permit alleged to have been issued by the administration on 15/5/2011. Thereof, the TV's court having fully aware of about the special permit issued by the administration to the petitioner's father, in recognition of his meritorious service on 29/3/1971, mechanically passed an impugned vacation order dated 13/4/2017 without examining the authenticity of the alleged land permit, which was produced by the Monian unit dated before the TP's court on 13/4/2017. In this regard, it is also made clear that the alleged land permit was issued by the authorities behind the back of the petitioner, or in other words, the alleged land permit was issued without the consent and knowledge of the landowner petitioner. Therefore, the illegal land permit dated so and so, and the impugned vacation order dated 13/4/2017, which was passed by the head TP on the strength of the illegal land permit, are liable to be quashed and set aside in the interest and for the ends of justice.
Okay,
So-
so
Yes,
I have a quote at 1:5 also.
yes.
So what do we do? We may continue at 2.
Your lordship.
Lordship, probably today I will not be able to submit, Your Lordship. I have one fixed hearing item and item number 21 also, Your Lordship.
This part will then complete.
Yes.
Because in any case, the morning also I told that this keeping CAB will be difficult to carry. So
Correct.
since I'm coming next,
Lordship.
so we'll complete the hearing
Yes,
from your side
yes,
also.
Your Lordship. Because I will be needing some time, Your Lordship, for my submission.
Okay. Hmm. Yes. So anything else, Mr.?
No,
Yes,
your lordship,
yes.
this is all.
Yes,
This
gone.
impugned order, this impugned summons
Okay.
and order.
This, but then, here,
Without any
the
jurisdiction.
person who has been affected,
Yes,
against whom complaint was lodged and against whom the
Yes.
Dabasi decided,
Yes.
he's not here.
but since he was representing me at that point of time,
Now you.
he is me, in
Hmm.
fact, because it is not land sold to him.
Hmm.
I had allotted him to stay there. It is not a permanent building also. He is
Okay.
still staying there.
He was temporarily
He is
allowed by you.
constructed a temporary residence only. It is not, it is not a concrete building.
Okay.
Yes, it can be considered to be permanent because it
Now,
has-
what is the status? Whether he is
he is
still.
still there. Still, because of the stay order, he is still there.
Okay.
And now, in the meantime, next to his building, his construction, the Moni unit started some construction when this stay order was there.
Hmm.
So I have filed a contempt petition, which is still pending.
Okay. So otherwise, I heard
Yes.
you. So if
Yes,
there is any clarification
yes,
on the next date of
Yes, Your
hearing
Lordship.
from the government side,
yes.
we'll
We
have
will,
that also.
we can take it up on that
Okay.
day, yes.
So,
But cover us,
Hmm.
your lordship has now been made clear of my position. So
Okay.
after the government advocate,
Mr. Tongpok, sorry, where is he? Anything, any other matter? How many? One hearing. Is the hearing ready?
uh,
26.
Yes, item number 26 and 27.
Are you ready?
Some more time to file affidavit, additional affidavit.
Additional affidavit?
Yes, placing on record the office memorandum
Record.
2001 and 2004, Worship. For hearing,
Okay. Okay, in that personal, let us pass order in this. Heard Mr. Tongpok Pogner, land counsel for the petitioner. This is in, Mojo is in 88. Which it is?
yes,
Okay. I've also heard Mr. Mojo. Also appearing on the
In all the three matters.
respondent number 5. Appeal is also in item 88.
Lordship, I'm in 50,
Okay.
Lordship, 58, read petition 58, Lordship.
Okay,
On the number 6 and in contempt petition as well.
88. Okay,
58, respondent number 6, Lordship.
just
And
88.
contempt petition, respondent number 2, Lordship.
Okay. Mr. Angami, land counsel appearing on behalf of the respondent number 1 to 4, he is also present. However, a hearing on behalf of the respondent number 1 to 4 is deferred, is prayed for. Come, list this matter. Again, after
Lordship,
It will be after 2 weeks.
yes, your
No,
Lordship.
After 2 weeks.
Lordship.
Yes. As a part hard. This is a part hard. Okay, list this matter as a part hard after 2 weeks. Okay. And in 58. Huh? Had Mr. Pong, right? Land Council for the petition. I've also had appealer, Land Council appearing on behalf of the respondent number
6, Lordship.
6. They are also same, huh? Mr. Angami, deferred, huh? Okay, list after. As a part hard after 2 weeks. Okay.
Lordship.
Okay.
Obliged, Lordship.
Please, my Lordship.
Yes.
Lordship, I'm allowed to make a mention for hearing item 26 and 27, Lordship.
Okay. In 26 and 27, huh?
If I may be allowed to file an additional affidavit, Lordship.
Okay.
I want to place the office memorandum
Okay.
issued in 2001.
Mr. Santiago, Land Council for the petitioner. Seek permission to file additional affidavit.
Yes, my Lord, placing on record the office memorandum issued in 2001 and 2004
Okay.
on work charge recoloration.
Well, Mr. Santiago, Land Council for the petitioner want to place on record
the office memorandum
the office memorandum
issued in the year 2001 as well as 2004 on work charge recoloration.
by filing additional
My
affidavit.
Lord, my Lord.
The prayer can be prayer not objected. According the prayer is allowed. List this matter after.
2 weeks, my Lord.
Okay. According to prayer is allowed, huh? The prayer, okay. After?
2 weeks, my Lord.
After 2 weeks. Okay. Her present, huh? Miss Mary's present also be recorded. Is for respondent number?
For all the
Only,
respondents.
okay, all the respondent. Okay.
Much obliged.
This is 88. Okay. Yes.
Met with Lordship.
Yes, I have seen. There is
This
typographical error.
Mrs. Yes.
Uh,
This miscellaneous application, praying for the correction of the typographical error,
It was
appear in
heard
the-
only. You see, in your petition, it was mentioned, it was heard. So, but then,
So-
how it could, we have typed it as a fault. It was typed as a fault, isn't it?
It was written as a put on hold, HOLT.
Put on hold doesn't give, you see, carry any meaning. Put on hold only.
Yeah.
Okay, so any other things?
But only paragraph 4, then last paragraph that is however page 5/6. However, due to false claim made by the respondent 4, the petitioner land compensation has been put to fault. It should be
That
put
is
on
last
hold.
paragraph.
Paragraph minus 20 page petition is 20 minus
Paragraph 5, Your Lordship.
4
Page number
So is
20.
there and what, 4
last paragraph.
and last?
Yes.
How?
The very first sentence, Your Lordship, in page number 20.
Yes. Page number 20,
The
last.
very first line, yes.
Yes.
Page number 20, very first.
Line, Your Lordship.
How?
It starts from however due to false claim.
Yes, that is there.
False claim.
Where else? Where else other than this paragraph 4?
Paragraph 4 continuation, my lord.
No, that is there. However, due to false claim
Yes,
made by
ma'am.
respondent number 4, the petition
ma'am.
and compensation has been put to halt. It should
Halt.
have been halt. And
Yes, ma'am.
where else? Anywhere else?
No, no.
Only this.
Yes, my lord.
Okay. See how it is fault. Okay.
Instead of my lord H, they have this typographical mistake, that is F.
You must have heard.
So,
We
so this
see.
may be kindly corrected, my lord.
That is why it's very difficult. You need to know the meaning. Okay. Heard Mr. Tayamson, Land Counsel for the applicant. I have also heard Mr. Rira, Land Counsel, Land Government Advocate appearing on behalf of the state respondent.
1, 2, 3.
But,
1 to 3, Your Lordship.
1, 2, 3, huh? 1, 2. This is an application seeking for modification, correction of the typographical errors. So alteration of the order dated 28/3/2025 passed by this court in WPC, writ petition C number 135/2025. Within brackets, Metaso, Mimi, and 13 others versus the state of Arunachal Pradesh and others, bracket close. The land counsel for the petitioner submitted in the paragraph 4, which appeared in page 4/5/6, 5/6 in column, in the last line. It has been incorrectly typed. The word halt instead of halt. Therefore, praise for correction of the same. Stop. The prayer. The prayer and the, okay. The prayer is allowed. Accordingly, the paragraph 4 of the said order
On the point.
shall be read as under start. The prayer is allowed. Accordingly, the word halt stands corrected as
Halt.
halt. Stop. And paragraph 4, and the last line of the paragraph 4 shall be read as under stop. Colon. However, due to false claim made by the respondent number 4, the petitioner's land compensation has been put to halt. Inverted comma clause. With the above, the word fault in the above sentence stands corrected as halt. Stop. This order shall be read along with the order dated 28/3/2025, passing WPC number WPC 135/2025. Stop. The I stand disposed of. Okay.
Much obliged, my lord.
Oblige, Your Worship.